Hello students, today's lesson is over the JU 3 through 5 goal notes. I apologize in advance. Some of you may have already got some of these notes perhaps in class, but if so, you could fast forward about, 5 or 10 minutes of this video and pick up where you need. But I'm going to take you through, this will correspond with the JU 3 through 5 notes sheet, which you should see up on the screen. A couple of resources to point out to you. If you are on Canvas, you could see this link down here has been added, the JU 3 through 5 Supreme Court info link. And that will take you to this page right here, which in addition to your textbook has some good information about writs of certiorari and oral arguments and briefs and what some of these other things are. So I'll do my best to explain them for you during this lesson, but you also can go online and find some additional resources from based on this link right here. So I wanted to point that out. Otherwise, if you want to take out your notes sheet so you can kind of follow along. Judicial review, of course, is the first thing on there, and judicial review is the right of a court to declare a law to be unconstitutional. This is the procedure, and this is really what federal courts, starting with the courts of appeals, and what the U.S. Supreme Court are really all about. Nebraska's state Supreme Court would also have the power of judicial review, and their job is to decide whether state of Nebraska new laws correspond with or are in accordance with the Nebraska state constitution. So the main role of a Supreme Court is not to declare something guilty or not guilty, and it's not to say this side wins the lawsuit. When they consider a case, they're considering whether or not the information presented is within the grounds of the Constitution. So the example case that we had learned about where the Bethel School District versus Frazier, for example, where the kid gave the inappropriate speech to the class, the student body. The Supreme Court, when they heard that case, they're not judging whether or not the principal should be guilty of suspending the kid, or whether the kid was guilty or not guilty, or whether the kid should get money for the lawsuit. They're deciding, is it okay for a school to censor a student's speech when it is potentially inappropriate? They're deciding because based on the First Amendment to the Constitution. So they're deciding, is the act of the principal constitutional based on the First Amendment? Okay? And the idea of judicial review comes about with the case Marbury versus Madison. Marbury was a judge who had been appointed by President Adams. So what happened was Congress passed a law called the Judiciary Act of 1789. And right towards the end of his time in office, President Adams appointed several new judges to these positions. And Marbury was one of the judges that got appointed. And what happened was he never received his commission papers that said, hey, congratulations, you're Justice of the Peace for Washington, D.C. And so when the new president, Jefferson, came in, he told his Secretary of State, Madison, not to deliver the papers, and Madison didn't. So Marbury sued Madison, and in those days, if you sued somebody, you went straight to the Supreme Court because it was really one of the only courts you could go to. And the Supreme Court, after deliberation, first of all, they were on the side of Marbury. They're like, yeah, you probably should have got your papers. He shouldn't be able to hold that from you. However, we say the entire Judiciary Act of 1789 is unconstitutional because they said it had extended the original jurisdiction of the Supreme Court. The Supreme Court's jurisdiction is set out in the Article 3 of the U.S. Constitution. So long story short, you can't become a judge because the law that created your judgeship is unconstitutional. So from then on, the Supreme Court has always done the job of judicial review. And their entire job is to decide if things are unconstitutional or not. All right. The judge that made that ruling was John Marshall. He's one of the more famous judges. He was actually the fourth judge of the Supreme Court, Chief Justice, of the Supreme Court. The first justice of the Supreme Court was John Jay. The Supreme Court usually uses its appellate jurisdiction, although technically it has both original and appellate jurisdiction. Most of the cases that go to the Supreme Court come through its appellate jurisdiction. So when would it ever have original jurisdiction? 2 times. If there's states involved, if multiple states are involved, original jurisdiction can be used. And if an ambassador or public minister is involved, the Supreme Court sometimes will choose to hear the case first. But far more cases come through what's called appellate jurisdiction of the court. There's 7,000 or 8,000 cases, depending on which source you use. 7,000 or 8,000 cases get appealed to the Supreme Court each year. And of those, they'll take between 100 or 200 of them during their term. And of those 100 or 200, some of them the Supreme Court just will make a quick ruling on. They won't even invite oral argument. So really only about 80 times a year does the court hear oral arguments. But just know that there's between 100 or 200 cases that get decided by the Supreme Court every year. And it's not a finite number. They can take as many or as few as they want to. But over history, this is kind of what's typical. However, the judges choose to not hear some of the cases for a few reasons. So of those 8,000, they're only going to take a couple hundred. So that's 7,800 cases that don't get chosen to be taken by the Supreme Court. The main 2 reasons they don't take someone's case is, 1, they agree with the lower court's ruling, and 2, they don't see it as a national issue. The reason the Supreme Court's going to take a case is if it's a big issue right now, or maybe the 8th Circuit Court, which includes Nebraska, that's based out of St. Louis, maybe that circuit court made a ruling on one side of a case, and the 9th Circuit ruled the complete opposite way. So what you would have is the 8th Circuit area, including Nebraska and Iowa, their law means one thing, and that exact same issue could be illegal in the West, where the district, where Judicial Circuit 9 is. So if there's a lot of national controversy and different courts are ruling different ways, the Supreme Court is more likely to take that case to make a final ruling that the whole nation has to abide by. So, how does it get to the Supreme Court? Most cases reach the Supreme Court by writ of certiorari, and I apologize in advance for how to pronounce it, because no one really knows how to say certiorari, certiorari. No one knows. I choose certiorari. Usually they just call it cert. So what does cert mean? What is a writ of cert? Well, that's the main way you get a case to the Supreme Court. In which case, the way it starts, is the lower court, the side that loses in the lower court. The losing party of the lower court petitions or asks the Supreme Court to take the case. That's the first step. The second step is the Supreme Court judges then, they get a whole list of cases that that somebody wants them to decide. So the court meets in conference. Usually that's on Fridays. We'll learn about that in a minute. On Fridays is when the court meets in conference, and they decide in that conference which cases they're going to take. If 4 judges agree, then they will take the case. It's the rule of 4, they call it. It takes 4 of the 9 judges to agree to take the case. If they agree to take it, they put it on the docket for later in that term, and then they'll decide it later on. The third step is then the Supreme Court issues what's called, issues a writ of certiorari. And that is an order. A writ is an order. It's like a legal order. And there's other types of writs that you may have heard about in history. A writ of certiorari is a requirement or an order for a lower court, usually the Court of Appeals, to send up the case to be reviewed. Okay, send everything you have. Send up the record. Send up your ruling. Send up the facts about it. Send up the testimonies and the briefs, and we'll take over from here. Okay, and that is the 3-step process of how most cases get to the Supreme Court. The least used way is this B, by certificate. On occasion, the lower court will actually just ask the Supreme Court to hear the case itself. So neither party had to ask. The lower court is maybe unsure of how to rule, and they could ask the Supreme Court as well. All right, the back page now of your study guide. Number 10. When is the Supreme Court typically in session? It starts in October. The Supreme Court is legally required to start the first Monday in October, and it finishes when they get done with all the cases they took. Traditionally, it's about the last week of June, first week of July. And probably in April or May, the Supreme Court stops hearing oral arguments, and they continue to meet just to write their opinions and deliver their opinions from the cases that have been heard in the past. So it takes a few weeks to get everything written down and get organized and to take the vote and to decide exactly how they're going to rule and to get it all worded, because what the Supreme Court issues as an opinion, as the opinion of the court, that basically becomes the law. And at least it's the interpretation of the law. So they take their time and make sure every single word is chosen very carefully. So, and usually it'll be a few months before they actually announce how they ruled. So if you hear oral arguments today, it'll probably be a few more months before you actually hear who won your case. Because they want to be that careful. So they continue to announce things and they continue to write opinions through June and July, but really they're probably done, at least in May, hearing oral arguments each year. So what goes on during the week? Question 11. What goes on during the week? The Supreme Court works in 2-week sessions. The first 2 weeks, they say the court is sitting. That means they're holding court. They're having oral arguments, they're voting, they're deciding the outcome of cases, and then they're announcing opinions during those 2 weeks. I found online that during those 2 weeks, they might hear as many as 24 different cases in a 2-week sitting. So, and they only work Monday through Wednesday. As far as in session, they're only sitting from Monday through Wednesday from 10 till 3. So you'll have multiple cases heard in a day. Because remember, most of what goes on behind the scenes. The oral arguments and what we actually can hear and see, we can't see because there's no video allowed, but what we can actually hear and what is reported on only takes place within a few hours, 3 days a week. The next 2 weeks then, the court will be in recess. And during that recess, there's no new cases being heard as far as oral arguments. They're writing their opinions and preparing their next rounds of oral arguments, reading the briefs and reading up on their cases for the next 2 weeks. So they hear cases for 2 weeks, take 2 weeks to prepare and to finish up the old cases and to prepare for the new cases, and then they repeat 2 weeks on, 2 weeks off, all the way from October to May. All right, question number 12. Describe the process of oral arguments in the Supreme Court. This is something we've already talked about. Just so you know, it's not like what you would picture on a courtroom drama where the lawyer is making this impassioned speech to a jury. The lawyer for each side, the lawyer for the petitioner goes first. The petitioner is the person who brought the case to the court in the first place. And that lawyer has 30 minutes to present his case to the 9 Supreme Court justices. But they don't give just a 30-minute monologue. The judges are constantly interrupting them with questions. We've probably already heard the oral arguments in the Morse v. Frederick case, but you'll note that the judges are constantly asking questions, and it's more of a dialogue than a presentation. After the 30 minutes are up, or once the petitioner's lawyer is done, if it's sooner than that, then the respondent, or the defendant at the Supreme Court, the respondent's lawyer gets to go for 30 minutes, and the judges will ask him or her questions as well. Most of what they know in the case is from the briefs, number 13. Briefs are written documents or written arguments about the case. Both sides, the petitioner and the respondent, will have already submitted briefs long before the oral arguments take place. And you'll also have these briefs called amicus curiae briefs. Amicus. The root amic is friendly. Amicable, it means friendly. So amigo, if you can think of amigo in Spanish, is friend. Amicus is similar to that. It is friend of the court. An amicus brief is a brief filed by a group that isn't specifically mentioned in the case, but it is a group that has a vested interest in the outcome of the case. So in Morse versus Frederick, for example, the United States government actually filed an amicus brief. They weren't either, right, it's Morse, the principal, versus Frederick, the kid. The U.S. government isn't even in the case, but they filed a brief on behalf of Morse, the principal, because of all the money that they had spent, the U.S. government had spent on anti-drug programs in schools, and felt that the principal should have won because she was just trying to prevent drugs in schools, and the U.S. government has an interest not promoting drugs in public schools. So they filed a brief urging the court to rule in favor of the principal. On the other side, the ACLU, the American Civil Liberties Union, filed a brief, an amicus brief for the student, saying that students should have rights to say whatever they want. The Constitution gives them freedom of speech, and students pretty much, as long as they're not disrupting learning, they should be able to say things even if it's unpopular. And they would argue that, yes, this message may have been about drugs, but that's okay. It's just unpopular. There's no reason you can't have that out on the street during a school event. The Solicitor General, number 15, is just the lawyer for the United States. During a Supreme Court case, if the U.S. is ever a party, the Solicitor General, he is one of the under-secretaries of the Attorney General's office. The Solicitor General is the lawyer for the United States who would argue in front of the Supreme Court. On a Friday in the Supreme Court, Fridays the judges meet in conference. They call it Conference Day. Both during the 2 weeks the court is hearing arguments and during the 2 weeks where they're not. The court, the judges, all 9 judges meet in conference on Friday where they decide that week's cases. They vote on the case. So we know, like, many of the votes of the cases we've been covering are 7-2. The 7 judges voted for one side and 2 voted against. So the judges vote, and then they decide who's going to write the opinions of each case. That is also the time where they use their rule of 4 and decide which cases they will accept. That also goes on Fridays. The opinions. Number 17 is about what is the majority opinion. At the end of every Supreme Court case, you will always have an opinion issued by the court. That opinion is called the majority opinion. It is guaranteed every single court case will have a majority opinion, also known as the opinion of the court. It states the official position of the court. It'll give a synopsis of the case. It'll tell the vote of the judges, and it'll have a detailed explanation as to why they ruled as they did. This opinion, the opinion of the court, is the most important one because it sets the precedent. It becomes the law or the interpretation of the law. The majority opinion is the precedent for all future cases, and it also tells the rest of the country how they need to interpret going forward this particular law, whatever the law is that is being debated. So once the Supreme Court ruled in Roe versus Wade in 1973 that the state of Texas couldn't outlaw abortion, that opinion of the court told the entire United States they must allow abortion. Every state must allow abortion because the Supreme Court has interpreted the Constitution to mean that abortion is a right that a woman has at least at some point in her pregnancy. So that right away made abortion legal for all 50 states. Similar with gay marriage a few years ago. Some circuit courts had ruled in favor of it. Some circuit courts had ruled against it. The Supreme Court finally took the case, and they ruled that states cannot distinguish, discriminate between same-sex couples when they're issuing marriage licenses, therefore legalizing same-sex marriage in all 50 states. All right. Every Supreme Court case will have a majority opinion. It is written. Oh, I missed that. It is also written by either the Chief Justice himself, if he's on the winning side, or the Chief Justice can choose any justice on the winning side to write the opinion. If the Chief Justice is on the winning side, he might choose not to write the opinion. He could delegate another winning judge to write the opinion. But one of the judges on the winning side will always write the opinion of the court. The dissenting opinion. The word dissent is to disagree or to go against. The dissenting opinion is written by any judge on the losing side. So if you are on the minority side against the majority, you may choose to write a dissenting opinion to tell why you voted against the majority. And it does not have the force of law, but it's good to kind of see when the judges are deliberating why some of them came out on the against that law, saying it should have been unconstitutional or should have been constitutional, whatever the opposite of the majority may be. So there is not a dissenting opinion with every case, because if the justices agree, all 9 of them agree, then there's no need to have a dissenting opinion because they would all agree. There could be multiple dissenting opinions. If 3 judges were on the losing side, each one might choose to write a dissenting opinion. What happens most often, though, is one justice will write the dissenting opinion and the others will just agree. And they will join him in dissent, it's said. And when you get into some further cases here, you'll see how there are some multiple dissenting opinions on some cases. The third type of opinion is the concurring opinion. Concur, of course, means to agree. So a concurring opinion is the rarest of opinions, but they do occur some of the time. That is a judge that voted with the majority but had different reasons. A concurring opinion could be any judge on the winning side of the vote, but they didn't agree with the majority's reasoning. Yes, I agree with this ruling, but for a different reason. Okay, we'll see examples of that as we go further. There may or may not be a concurring opinion on every Supreme Court case. Some of them will have none, and some of them could have multiple. You could have different judges agreeing with the majority, but not for the majority's opinion or reasoning. And the last thing is reversal. Sometimes the court does reverse itself. If you think of what reverse means, it means to go a different direction, go backwards. From if you were going forward, you reverse and go backwards. You change course. The court reverses itself when it rules differently on an issue today than it did in the past. So the Supreme Court is a continuous body. Right? They don't have elections. They don't all leave the court at one time, and you don't have new people. You just have like one at a time every once in a while. So the court is a continuous body that has met ever since the beginning of our country in 1789. So when the Supreme Court reverses itself, in the past, it may have ruled a particular way on an issue, and now today, in the present, it might change its mind. Okay, because times change. Things that were seen as maybe illegal, unconstitutional as a big deal, 50 years ago, might get reversed today by the current court. Okay, or the new makeup of the court, because the judges change periodically as they die and resign. The new judges might feel differently or might interpret the law differently. So a reversal is when the court rules differently than it did in the past. And I use the example once again of Roe versus Wade. In 1973, the Supreme Court voted to make abortion legal in all 50 states. That doesn't mean today they couldn't take a case and vote that a state has the right to limit abortion. There's nothing in the Constitution that mentions abortion at all. So it's possible today that a conservative Supreme Court could take an abortion case and completely reverse Roe versus Wade and say, yes, states, if you want to outlaw abortion, go for it. We don't see anything in the Constitution that guarantees a woman's right to have an abortion. So if the court were to do that, that would be considered a reversal of itself. All right, hopefully some of this made sense to you. You will have a Canvas quiz over both JU3 and JU5 that you need to take, and you could get started on those. You'll find them both on your Canvas account. Here's JU3 and here's JU5. So have a good day, and I'll see you later.